Everybody, and welcome to this launch event for the Scottish Law Commission's 11th programme. Now, you see up there that this meeting is being recorded, but I don't want you to panic because we need your consent for that. So what we're doing is just recording everything, but then we're editing. Cross my heart, okay, and swear in my granny's grave. We will only take the presentations from our commissioners, and we won't include the questions and answers or anything like that, so don't fret. It will disappear shortly, I hope. Then another thing I wanted to say is mask wearing. It's no longer mandatory, as you all know, but feel free to wear one if you feel more comfortable. Then what we're going to do is each commissioner is going to give a presentation about possible projects for the 11th programme, and subsequently we will open the floor for questions and suggestions for our 11th programme. And then importantly, at the end of all of that formal bit, we're going to have a glass of wine. So let's proceed immediately to business. So as you all know, law reform is essential for a healthy legal system and a fair society. Anything that's not working well, or is unclear, or is unfair, or requires updating should be addressed and resolved by the appropriate legislation. That is certainly the goal of the Commission. And I just want to remind everybody that there have been some very successful recent examples. Just going to try and see if I can look at that. There have been some successful recent examples of the modernisation of Scots law and the resolution of problems and unfairnesses. And I'm only going to mention a few, but electronic signatures, they have become essential in modern life, particularly during the pandemic, and they became available in Scots law thanks to Hetcher McQueen, basically, and thanks to the legal writings Counterparts and Delivery Scotland Act 2015. So that's a success story. And then securities over movables. I'm going to embarrass Professor Andrew Stephen by mentioning his name. This is going to be essential for modern business and modern loans and so on. And we hope that this will shortly become available through the Movable Transactions Bill, which is currently going through Parliament. Then what about time bar? I want to mention time bar and the law of prescription because I have a personal interest in the case Morrison against ICL Plastics. That case caused major problems. It was a decision of the Supreme Court in 2014, and I'm afraid it resulted in completely unfair cases where prescription, the 5-year prescription ran, even though the victim, as it were, the deprived party, didn't appreciate that there was any loss at all. There have been 1 or 2 rather terrible cases showing that you lose your claim before you even knew you had a loss. However, that's been solved now by the Prescription Scotland Act 2018, and that was brought into force fairly recently. We're delighted that it's in force. And what about the law of defamation? It has also been updated and clarified by the Defamation and Malicious Publication Scotland Act 2021. And as the Chief Executive advised us today, some of the commencement regulations have just been laid, I presume that means laid before the Scottish Ministers, laid in the Scottish Parliament, and it will bring more of the Act into effect on the 8th of August. So that's good news. And then lastly, but very importantly, and it's good to see Lord Drummond-Young here, it's hoped that trust law reform will shortly go through Parliament, and that's just provided that space can be found in the parliamentary programme. So fingers crossed, and I'm looking very squarely at Jill Clark there, yes, because I know she's in charge of that sort of thing, or at least helps. Right, so these are all recent examples, but I wanted to mention one more historic example, and that is the removal of the need for corroboration in civil cases. That was as a result of Commission recommendations. It came about shortly after the Scottish Law Commission had been created in 1965. There was a Commission report in 1967, followed by legislation in 1968. So that's a very early example. The reason I wanted to refer to this more historical example of improvements in Scots law, thanks to the Law Commission, it's for two reasons. First, there's perhaps a resonance with the current debate about corroboration in criminal law and the possible abolition of corroboration there. But secondly, and this is secretly my main reason, I wanted to show you the size of the 1967 report. It's 11 pages. So I just thought, well, I mean, if they can do it in 11 pages, you know, should we not perhaps be learning something from this? And so I'm going to recommend the haiku approach from now on. And all commissioners should note that. I mean, look at it. Okay, with that background, our message to you today is simply that the Commission is keen to hear from you about reforms which you think are needed. We're approaching the end of our 10th programme, which covered the 5-year period from 2018 to 2022. And we now have this golden opportunity to address new problems in our 11th programme. So we need your help and suggestions. I suggested to Charles that we should have some paper consultation forms. Have we got them? No, right. Well, you'll have to go electronic, everybody. Sorry about this. There's an electronic form which can be accessed on the Law Commission's website. So, you know, feel free just to access the website, the consultation part of it, and fill in the form that you find there. If you think some area of the law requires reform, just please let us know, because we really do benefit from all sorts of suggestions and contributions. And can I say that we've had some contributions already, and they're fascinating. So here's one. A retired sheriff who's not actually here today, lives up near Stonehaven. You probably guess who it is, but anyway, he has focused on powers of attorney. As you all know, many people grant a power of attorney just in case. So it's not that they're failing in any way, but often their lawyer will advise, well, you're doing your will, just do a power of attorney as well. Unfortunately, sometimes in these circumstances, a power of attorney seems to be able to be abused. The sheriff reports of an elderly lady who went into hospital for a minor matter. She was perfectly intellectually okay. She was sharp. She was compos mentis. There's no question of not knowing about her affairs. Unfortunately, what happened then was her son, who had the power of attorney, which was the just in case power of attorney, withdrew all her money from her bank account, leaving her with £26,000. And he also surrendered her local authority house. He then left the country and he's now living in Spain. So the elderly lady is homeless with only £26,000 in her bank account. And the sheriff assures me that from what he's learned, this is not an isolated case of misconduct. So the sheriff asks, are there gaps in the law? Are more safeguards needed? And could new technologies help? And the new technologies might include, for example, the bank, who's asked to make a payment by the attorney, sending the alert elderly lady an alert text. Because all of you who are doing electronic banking will have had the experience of, you try and make an electronic payment and immediately your iPhone pings and it says, you know, there's a new payee, let's say Sheriff Sean Murphy QC. You know, if this was not you who fixed that up, would you get in touch? And so it strikes me that this might be a possibility which is worth looking into. Another interesting suggestion which we received is drones. Someone has pointed out that drones are extremely intrusive. They can be very destructive, and it's possible, although I don't know about this, that they may be inadequately regulated. So there have been standoffs at airports, as you probably know, and I had a personal experience of a castle owner telling me So just 2 weeks ago, Castle Stalker near Appin, if anybody knows it, Mr. Allward, who owns the castle, had a drone crashing into his castle, having buzzed around all afternoon and bothered him. And then the French tourist phoning up and saying, I wonder if I could come onto your island and retrieve my drone. Got a pretty dusty answer, but should the law be looked into? That's what he wanted to know, having learned that, you know, where I worked. So another suggestion has been, this is, so you've got powers of attorney, we've got drones. Another suggestion has been digital assets. And so that's cryptocurrency, blockchain, electronic trade documents, smart contracts. We feel that this is a cutting edge area in the law, and David may mention it in his address to you, and Gillian also may mention it. So our question to you today and our request is, do you have any topics to suggest? If so, we'd be glad to hear from you. So I'm now going to invite my fellow commissioners to just address you on a few possible projects, and we'll call on David first. So we have to do a French box.
Thank you very much. Both of our
wait, we'll stop, David. We're recording. The camera is here.
Right. No slides, I'm afraid. However, as I was going to say, and indeed, as Scotland's two Supreme Court judges have said, it is absolutely critical for both the Scottish business community and for society in Scotland in general that Scots commercial law keeps up to date and in pace with developments in business practices and just generally how society deals with each other. This is something which the Scottish Law Commission has always been in the vanguard of, as Anne mentioned. And there are three areas in particular which we've noticed that may require reform. The first of these, Anne's already referred to, digital assets. Digital assets, this incredibly broad spectrum that is covered by that term. We can begin with photographs on somebody's computer, and then that can be expanded out potentially to something like digital art, which can now be quite valuable. We move on then to music downloads, a little more into cryptocurrency, things called non-fungible tokens. I don't know if any of you dealt with any of these and thought about how they might differ from fungible tokens. It could be lots of other items in a digital format that people haven't even thought of. That's the way that things seem to be going. The question for the law is, how should they be categorized? And we've come a little distance from the original copyright sort of analysis of all of these things. You know, everyone has them. The law, it seems to me, must move on. We already have our categories of property. The question is, which category do digital assets fall into, if any category? So, for example, one might think they're incorporeal movable property, but does that mean that they're transferred by an assignation? So, categorization is critical. Linked with that is verification of ownership. How does one identify who owns the asset? Is it the person who holds the computer that has it on its hard disk? Or is it somebody who has registered the digital asset somewhere? Those are just a couple of options. But that's very important because it links in with the question of transfer of assets. Obviously, you have to be the owner to transfer the asset. And then there's the overriding question of really whether Scots law applies at all. Some of these assets may be in cyberspace, whatever that is. If that's the case, why should Scots law apply? Why not another law? Why not the law of the company that provides the social media account? So there are all of these factors to be considered, which our law has to answer. And at the moment, it does not appear to me, at least, that there are these answers available. And that has an effect on commercial investors. I mentioned cryptocurrencies. There are, in fact, some Scottish enterprises who've sought to launch these in Scotland. It also affects private individuals and things like inheritance and succession. Indeed, solicitors already have come across cryptocurrency in a succession context. So digital assets. The second area, digital transactions. Anne mentioned the Legal Writings Counterparts and Delivery Act. That act, together with various other provisions, have adopted, dare I say, a piecemeal approach to the use of digital documents. Generally speaking, countries throughout the world have gone one of two ways. They've taken either a sort of micro approach or a sort of macro approach. And the micro approach involves specific pieces of legislation for specific activities. So the judiciary amongst us will have noticed that judgments can now be done in a digital form, and that was enabled by a statutory instrument. But there is also the macro approach, which essentially allows things to be done digitally, allows anything that can be done in paper and anything that could be signed, any requirement for signature, to be done digitally without the requirement of a complex electronic signature, such as the one that we get in the Requirements of Writing Act. And essentially, this is the way that people really do things. And it seems that if our law doesn't give full effect to that, that's something that should be looked at. The macro approach has been used in the United States since about 2000, without little demur. Other Commonwealth countries like New Zealand have it. And in fact, there's a Commonwealth model law issued in 2017 with this all-embracing approach. Question is, where is Scots law in this? Arguably seeking to catch up. And then finally, leases is a project that we're about to complete in relation to termination of leases. During the course of this, two topics have arisen which are worthy of further consultation. One is the Tenancy of Shop Scotland Act, which where we originally suggested possibility of repeal. It appears that, certainly since the coronavirus crisis, there may be other solutions available, and that's something upon which we think that further consultation would be appropriate. The balance to be struck there between the interests of the small businesses that the Act was meant to favour and landlords. Then there is the question of confusio, when a tenant becomes a landlord, a difficult topic where again there's scope for further consultation as to what may be a proper solution for Scots law. And finally, a couple of other topics, the transmissibility of obligations from landlord to landlord in a lease. Sometimes Latin internaturalia, the fact that we speak of internaturalia in itself may illustrate the fact that this is slightly obscure and not as clear as it could be, but it's important for landlords to know what they're taking on and for tenants to know what is restricted. And then finally, repairing obligations and dilapidations claims. The idea is the damages are there to repair the property, but how often is the property actually repaired with the damages that are awarded? Possible area for reform. So echoing Anne's invitation, those are just some ideas, and we'd be very grateful for your views, not just on those ideas, but indeed on anything that you yourselves may think of. Thank you.
Thank you very much indeed, David, and we're now going to ask Julie to comment on one or two possible projects.
Thank you, Anne. Thank you, everyone. Well, I'd like to be the third commissioner in a row to stand here and tell you about digital assets. I too have an interest in them, and I wonder if one particular aspect of digital assets that we need to look at, either as a standalone project or part of a wider review of digital assets, is how they operate in the family context, and particularly when a relationship comes to an end or when one of the spouses dies. And I think perhaps we fail to reflect on the vast amount of our lives, our personal lives, that are stored digitally these days. So when a marriage comes to an end, who gets to keep the digital photos of the children? What order can be made for them to be shared between the spouses? And likewise, if one of the spouses dies, what access can be ordered to social media accounts, Facebook, Twitter, etc. So I think one thing that we do need to consider is how the law deals with digital assets in a family context rather than a commercial one, particularly at the end of a relationship, whether through death or divorce. So I'd be keen to see that, and I'd be very interested in your views. I'd be keen to see that either as a standalone family law project or part of a wider digital assets review. Another possible project for family law, and I'd be very keen to hear views on this, particularly as to whether it's something appropriate to come to the Law Commission or whether indeed it's now a matter of policy for the government to review, is the question of divorce. And those of you that follow divorce law closely will know that in England, they have recently reformed their law just last month to introduce no-fault divorce. So it's now possible for the spouses to seek a divorce without pointing the finger of blame in either direction. And critically, they've also introduced mutual divorce, whereby both spouses can petition together to seek a divorce. And that's very important in ending the relationship in a positive, constructive manner, rather than one party being the pursuer and one the defender. Scotland is one of a diminishing number of European jurisdictions which still has fault as a basis for divorce. We do have separation grounds which are non-fault based, but we still have adultery and behaviour. And whether that's appropriate in the 21st century is something that it would be interesting to reflect upon, and I'd be very keen to hear views as to whether this would make an appropriate project for the Law Commission to tackle in our next programme. And the third topic I just wanted to mention briefly, moving away from family law to contract law. I'm sure you're all aware that under Professor McQueen's stewardship in the 10th programme, there was an extensive programme of contract law reform resulting in the 2018 report on contract law. And it touched on a lot of areas, including formation, interpretation, remedies and penalty clauses. But one area which Professor McQueen could not, to his regret, cover in his time was illegal contracts, pacta illicita. And I think that that is something which would work as a very discrete standalone topic for the Law Commission to investigate. It's one which has changed recently in English law with the involvement of the Supreme Court in the decision of Patel against Mirza from 2016. But the lower English courts are starting to roll back from some of the impact of that Supreme Court decision, and the impact this has on Scots law, I think, is worth considering. So what is the position of illegal contracts in Scots law? And I think that would make a nice standalone project to complement the work done by Professor McQueen in the previous contract law project. So those are my three thoughts, but of course we're very keen to hear not only on our suggested topics, but from all of you. I know that the consultation closes on the 29th of July, so if you can put that date in your diaries, but of course I'm sure you've got holidays planned for July, so feel free to get your responses in June if possible, and encourage your colleagues, your students, your friends, no doubt, I'm sure everyone's got a view on law reform, and any responses to our consultation by the 29th of July would be much appreciated by all of us.
So thank you very much for that, Julie. So now we come on to Kate to tell us what she thinks. Thank you.
Gosh, it's nice to be in an actual room speaking to actual people. Thank you all for coming. I'm currently leading the Aspects of Family Law project. We decided to approach the project in phases, and we're coming towards the end of phase 1, which deals with reform of the law relating to cohabitation when cohabitation comes to an end otherwise than on death. And we're hoping to publish our report in June for those of you who are interested in that. Now that programme was included, our project was included in the 10th programme, and so was expected to continue from 2018 until 2023. So we still have a bit of time to include other phases in the project, which will of course be likely now to spill into the 11th programme of reform. We're turning our minds now to phase 2 of the project, and we are hoping that what we'll be looking at during phase 2 will be civil remedies for domestic abuse. Specifically, our aim would be to reform the law in that area by making remedies more accessible and looking at whether remedies can be improved to make them more effective and provide greater protection. and focus on prevention more than prevention is focused on as at present. If we undertake that work, as I say, it's likely that the family law project will continue into the 11th programme. So we'll be looking for other family law topics to include within the 11th programme. One of the areas where I think there might be some work to be done is on adoption and permanence and reform of the Adoption and Children Scotland Act 2007. There was some enthusiasm for that work to be done from respondents to the 10th programme consultation, and I'd be interested to see what respondents to this programme consultation think about that, because we've had several years now more working with the legislation, and I wonder whether the difficulties that were perceived at that time, which really related to the complexity of the legislation, again, accessibility, ability to understand what is a complex process and the length of time that adoption and permanence takes, and how adoption, permanence and permanence orders with authority to adopt all work together, and whether those issues have been resolved and whether the legislation appears now to be somewhat clearer, given that people have been working with it, and we've now got we've built up some jurisprudence on the legislation. So I'd be very, very interested to hear about that. There's a wider issue in relation to adoption, of course, which is whether we in Scotland should have forced adoption at all. And that's a much wider, much bigger issue for us to think about. But I would certainly be interested to hear from respondents on that. Still relevant to family lawyers, there are a couple of other matters that are topics that might be of interest, and certainly would be of interest to me, and I'd like to hear from respondents about whether they agree with me that there may be some work to be done. Those relate to, firstly, the law as it deals with contracts, contractual arrangements between spouses and civil partners, and also cohabitants, and specifically whether an undifferentiated approach should be taken to those contracts, regardless of the stage of the relationship at which the contract is entered into, and the content of the contract. For example, in an ante-nuptial contract, is that dealing with simply one asset and ring fencing that? And should that contract be treated in the same way for legislative purposes as a contract that's entered into that deals with the whole of the matrimonial distribution of matrimonial property and assets once the relationship comes to an end? The law of civil evidence is also something that might be of interest, and certainly in the family law context, there is specifically an issue that is also associated with the question of domestic abuse and evolving knowledge and understanding of all forms of abuse, including coercive control. And that issue relates to the prohibition on making reference in proceedings to what takes place during family mediation. I wonder whether, since the legislation was put in place in 1995, I think it was, I wonder whether, since that legislation was put in place, our evolving knowledge relating to abuse in all of its forms would now determine that what we should be doing is looking at whether, in the context of family mediation, reference may, in some circumstances, be made to what goes on in the context of a mediation beyond the very fact that mediation took place, who was there, and that there was an agreement reached or that no agreement was reached at all. There are, I'm sure, lots of other areas of family law and lots of other wider areas of law where we could do useful work, and we would all be very keen to hear from all of you and from your colleagues if there are suggestions, if you have suggestions as to the content of the 11th programme, I, leading the family team, I and my team would very much like to hear from you specifically in relation to family law topics that we can include in phases 2 and 3 of our family law project and in the 11th programme as we move into that. Thank you.
Thank you very much indeed. And now we ask Frankie to round up. Thank you.
Thanks, Anne. I was so busy thinking about what Kate was saying there that I forgot that I had to get up and speak next, so might be disorganised. As everyone says, thanks very much for coming along. I'll just start by reiterating what Gillian said about the closing deadline for submissions being the 29th of July. There is a form on our website, but I should say that you could also just send us an email to info@scotlawcom.gov or just tweet us at scotlawcom. We're not the general office and will not bounce your responses for being in the wrong form, so feel free just to communicate with us in any way. We're very interested just to hear any ideas that people have. My role today is really to tell you about a couple of projects which are going to continue into our next programme and take up a certain amount of the slate, which is the 2 projects I'm leading on at the moment, one of which is on heritable securities and the other one on compulsory owners associations in tenement buildings in Scotland. The heritable securities project, as I'm sure many of you will know, is a large-scale project reviewing all of the law essentially in this area. That project was started in 2018 under the good offices of my predecessor, Professor Stephen, who's lurking worryingly at the back of the room there. The project started in 2018 and should finish up in 2025, which is obviously 3 years into our next programme. The project has an overall review of the law, so we've published 2 discussion papers already, one of which published in 2019 when Andrew was leading the team was on creation and transfer of standard securities. We published a second paper just at the end of last year on enforcement of standard securities, and we do have a third discussion paper which should be out at the start of next year, which is going to look at 2 specific more technical issues in the law of standard securities, one of which is subsecurity arrangements. In other words, where security is taken over a standard security, which in Scotland it's only competent to do at the moment by taking a standard security over a standard security, this kind of piggyback security arrangement. But we understand from practitioners who work in areas where these subsecurity arrangements are needed that that is a very unwieldy solution for what should be quite an efficient process. So we're going to look at maybe a better way, a better mechanism for trying to put those arrangements in place. The other issue we'll be looking at in the third discussion paper is security in respect of non-monetary obligations. So the classic of this is a security in respect of an option agreement, which I'm sure probably everybody in the room will have come across at some point. So the reason why people take security in respect of an option agreement is really about making the agreement visible on the face of the land register. It's about giving third-party effect to these agreements, which would otherwise just create personal obligations between the 2 parties. And at the moment, using a standard security is the only way that you can get these personal obligations onto the land register. But in other countries, England, Germany, Switzerland, they have a different, again, maybe a more elegant mechanism of achieving that outcome without, well, nobody else is using a heritable security for that purpose, but there are other ways of achieving that effect. And that's also something that we're going to be looking at in the third discussion paper. As I say, that should be out at the start of next year. All 3 discussion papers will be tied up together in a final report and draft bill, which should be out by the end of 2025. So that's already in the programme for next year, for the next programme, I should say. The other project that is being carried forward is one that has just started at the beginning of this year as a result of a reference from Scottish ministers on owners associations and tenement buildings. So you may know that the Scottish Parliament has been doing quite a lot of work over the past few years on disrepair to tenement buildings in Scotland, rolling into that questions of energy efficiency in light of net zero targets. There are lots of reasons why the tenement stock is not necessarily in a great state of repair, but the legal framework that applies to tenements at the moment is a part of that. And one of the recommendations that's come out of the work that the Parliament has been doing is that there should be owners associations for tenement buildings in Scotland as a mechanism through which owners of the flats can meet with each other, can be encouraged to take a more proactive approach to maintenance and energy efficiency related upgrades to the building. It could also be a body that is better placed to pursue owners who do not pay their shares of the costs of these sorts of buildings, and might also provide a body on whom responsibility can be placed for improved housing standards, energy efficiency standards, and so on. So this is a recommendation that has come out of Parliament and has come to us to consider the mechanics of how you might put such a body in place for the huge array of tenement buildings that exist with all kinds of different title arrangements and conditions in Scotland at the moment. So we got this reference in January this year. The project is still in the early stages. We're scoping the issues, we're speaking to stakeholders, and we're doing some comparative work. But there should be an initial discussion paper out, we hope, in the middle of next year, and that project is due to report in 2026. Those two projects will be going forward into the new programme. I do have one other very unglamorous project to suggest in comparison with, you know, digital assets and these sort of things, which is we might perhaps consider looking at consolidating the law of diligence in the next programme. The Law Commission, oh, some smiles in the audience, that's encouraging. The Law Commission has, over the past couple of programmes, carried out a few large pieces of work in consolidation of bankruptcy legislation. Andrew, as Anne previously mentioned, did this huge piece of work on movable transactions, which included security over movable property, which hopefully will result in legislation soon. Obviously, we're looking at security over heritable property at the moment, voluntary security that is. So in a sense, a piece of work looking at the law of diligence might be the final piece of that puzzle by looking at involuntary security in Scotland. This is obviously a law that is used day in and day out in the courts, but the law is not in a great state. There's several different pieces of legislation, primary legislation and secondary legislation. They don't all fit together the way that they should. This is a sort of work that is never going to win votes or perhaps be all that attractive for a parliament to look at. But for the Law Commission, in some respects, this is what the Law Commission is there for. So although it's not glamorous, I would put out a vote for doing this sort of work as a way of improving, tidying up the statute book and making the law more accessible for everybody that needs to use it. That's the end of my pitch. Do please, we're delighted to hear everybody's thoughts and the thoughts of your colleagues. No thought is too small.
Thank you.